Welcome back to Rethinking Politics, episode 67. We're glad to have you guys here with us today as we discuss some more current events and our takes on them. In this case, we are not going to be talking about the new COVID variant. I think it's a Megatron is the name of the new variant. Am I getting that right, Dan?
Basically. Except that doesn't then spell moronic, which is my favorite theory about it, right? Omicron and being... And anyway, nobody should... At this point, nobody should worry about a new variant unless it is first proven to be, significantly more dangerous, which it's almost guaranteed not to be because that's not the way genetic variation tends towards.
No, the only thing newsworthy about the Omicron variant is how crazy everyone's reactions to the Omicron variant is with so little information. On one hand, they're saying, "Oh, we have no idea." I think Fauci said something about how immunity may not be effective against it, and on the same side, they're saying this is why everyone has to get vaccinated because of this new imminent threat that we know very little about how dangerous it actually is. And it's something we've talked about before about the Delta variant and other variants, that there are going to be variants and there are going to be varying degrees of dangerousness. But in general, this virus should be getting less dangerous, not more dangerous over time with these variants. That in general, these variants may be more or less contagious, but it doesn't mean that they're more dangerous necessarily.
Right. Yeah, they should be getting less. Will be the long-term trend.
So I'm not too worried about it. We're not going to waste an episode right now talking about that. That may change. We make promises about not talking about COVID, and next thing you know, we're talking about COVID. But today, we're going to hold true to that promise. That minute was all you get. Instead, today, what we want to talk about is some criminal cases as I guess you could say, follow up to some of the stuff with Rittenhouse. We want to talk about two interesting cases that have been receiving media attention since the verdict. The first is Chrystal Kizer, and the second is Darrel Brooks. The second one everyone should be familiar with. Darrel Brooks is the suspect in the how do you pronounce that? The city name, Waukesha.
I don't know. I
don't know. But anyways, the man who drove his vehicle into a Christmas parade, killing several individuals and injuring many, many more, what was clearly a horrible, horrible tragedy, but has raised some really concerning questions about the justice system, because he was actually out on bail 5 days. He was released on bail 5 days before the attack, and the bail was $1,000 bail, so a very insignificant sum in relation to what he had been charged with. He's actually has several pending charges. I'm not sure if he's been convicted of anything. I haven't followed up on that enough, Dan, but I know he at least has several pending charges, including violent charges. He was shooting at some individuals as they were driving away, may have attempted to run someone over. Pretty serious charges,
right,
for someone to be out walking a few days later with basically no restrictions, right?
Yeah, he has been convicted of previous crimes. Obviously, he's served whatever time was necessary for those. His criminal record is very long, and including things he's been convicted of, others he's been accused of, and they didn't have sufficient evidence. But yes, he has, as you were suggesting, attempting to run someone over. This is not some he's got outstanding parking tickets, right? These are the kind of things where if he did that, maybe he shouldn't be wandering around. The kind of things that make you wonder, let alone on a $1,000 bail.
And then the other case that I wanted to talk about that ties in is Chrystal Kizer, who killed her alleged sex trafficker 3 years ago when she was 17. And since that time, she spent about 2 years in jail until 2020, where an advocacy group was actually able to raise enough money for her $400,000 bail that she was able to get out on bail. She's still waiting for her day in court, and is attempting to hopefully use self-defense in her defense after the Kyle Rittenhouse case. It's gained a lot of media attention, as a lot of people are calling for her to be acquitted after Kyle Rittenhouse was acquitted on self-defense grounds.
Yeah, it's interesting to see people who were involved in that case seeing the outcome of Kyle Rittenhouse and being like, wait, maybe there's hope. Maybe she can plead self-defense.
Which first of all is fantastic. It's exactly the kind of response to the Rittenhouse verdict that I think people should be having.
Yeah.
But why do we want to talk about these two cases, Dan? These two cases are interesting because it sparks a broader conversation into how the justice system works, and how, from start to finish. Bail is a huge part of that. Is what happens to people before they're tried. You look at the Chrystal Kizer case, and when you've got someone who's spent 2 years in jail before ever having their case heard, by my account, that seems like a serious problem, right? And then on the flip side, you have someone who 5 days after being released on bail, basically, a super insignificant bail, the $1,000 bail is not a real restriction with the way bail bonds are set up. That's so low that basically anyone can get out, right?
Right.
And so basically, he is charged with serious offenses and then released almost immediately, and then goes and kills, at least 5 or 6 people, and potentially others who are still many others who are injured. And the question is how does this make any sense, right?
Right.
How does this make any sense, and what is the solution?
It's even more ridiculous when you see that one of the things that he has been guilty of in the past is running out on his bail. Right. So
it's no bueno. Why would there be such a low bail for someone who's done that? Now the thing is that I know a lot of conservatives are looking at this and they're saying this is why bail reform is a problem. People tried bail reform, and now look at these people who are dead and these people who are injured because of bail reform. Bail reform is directly responsible. Yeah,
this ties in part into what's been happening in the years with George Floyd, after the death of George Floyd, where you have all these people committing petty crimes involved in the riots. And you'd have people like actors and actresses and other public figures with some money who would go in and they would pay all of the bail things for those people. And it's also the idea, there's a general trend that, hey, wait a second, a system of bail in which you assign some kind of charge to this,
a dollar amount.
A dollar amount favors the rich. And it gives it's discriminatory against poor people in some sense. It particularly penalizes them. So a lot of these ideas about bail reform, as you're saying, that the trend in a lot of states is for bail to go down, especially I think Democrats in particular. Of the two major parties, Democrats push that a lot. Others also push that. And so, as you're saying, people are like, well, here's the consequences of that, right? You get to the point where someone like this, who clearly should not have been let out, is able to pay $1,000 bail and gets out and then does something terrible. And
No, and the answer is not simply to raise the dollar amount, in my opinion. A great example of this is Kyle Rittenhouse himself. Let's say that things hadn't happened the way they did. Let's say Kyle Rittenhouse was actually guilty of murder and that he really did travel to Kenosha just to kill people. Like, that was his real purpose. Is he's actually secretly a sociopath who just wanted to kill people. He gets charged. He gets out on bail. because he's a bit of a celebrity, regardless of what the bail amount was, even if it was $1 million, he'd be able to raise it. You know what I mean?
Right,
Not
right.
him himself, but
yeah, it became political, and people on his political
Exactly.
side would have raised the money.
And so then he's out on bail, and he's free to do whatever he wants. Obviously within limits according to bail, but in practice, he's free to do whatever he wants. And he could have gone on a killing spree. Like I said, assuming that he really was some kind of, serial killer in the making, he could have gone on and he could have killed a bunch of people. And the bail system, as it's currently set up, would have done nothing to prevent that.
Right. And it could be worse. Like if he, you can imagine someone who clearly did, who the case is going to find them guilty.
Mm-hmm.
And then they get out on bail and they go and they're like, well, I'm going to be behind bars for a long period of time, maybe for life. In a short time, what do I have to lose? Right? This could be...
Yeah, or whatever reason they committed those crimes in the first place is still there, whether it's financial desperation or some kind of mental instability, which is, those two are often, it's usually both, there's some kind of serious issue combined with a different kind of serious issue, and the end result is that they may go back and do something else, and bail is not always an effective deterrent against that.
Yeah. Yeah, really, and you mentioned this to me, and this makes a lot of sense. If you just say, what is the reasoning behind bail to begin with? It's to give them some added incentive to show up to court.
Yeah, to show back up for the trial.
Because you pay this amount of money, and you get it back if you show up. It's very clearly has a limited purpose.
Mm-hmm.
But that's not all of the things that should be considered here,
mm-hmm.
right?
Mm-hmm. No, and there is a precedent for considering the threat to society in general, but it's pretty. It's very, very rare for someone to be held without bail. Like, it has to be an extreme case.
Yeah.
For the judge to say there's no chance of you getting out until the trial. It almost never happens except for the most extreme cases.
Yeah.
People who are getting tried for murder often get out on bail.
That's
that's Kyle Rittenhouse. You know what I mean?
Yes. Yeah.
He was charged with murder. And he's out on bail. He didn't spend the last year and a half in jail.
Yeah. Yeah, that's a good point. And that is something left to the discretion of the judge in the case. Is that correct?
I for the most part,
I think that's right. And that would make sense that in extreme cases, most judges probably rule one way, but it seems like the tendency now is in many other cases to set some kind of bail, and for that bail to be lower and lower. So
so where does that come in with my opinion? My opinion is simple: is that I think the biggest priority when you're there's a few parts to it. Number one, your biggest priority when you're looking at bail, I don't think should be whether or not they're coming back for the trial. I think it should be what is their risk to society, and we need a system that does something to protect society while also protecting people's rights, and the current bail system doesn't do it. And I think a great example of that is the Chrystal Kizer case, where she spends 2 years in jail because no one cares about her. And then people hear about her case and they raise money, to hit the $400,000 bond, and she's able to go free. Her risk to society never changed. In those 3 years, 2 in jail and 1 outside of jail, nothing changed when people heard about her story.
Yeah.
She was just as dangerous before as she was after.
Yeah.
What changed was her financial situation. And that's clearly a problem with the justice system, because the end result of that justice system is the people that don't have money, don't have connections, and don't have anyone on their side. In other words, the people in the worst possible situations are going to spend their time before their trials behind bars, and the people who have money or who have connections or who have people who hear about their story and are sympathetic towards them for whatever reason, whether it's because they appear innocent or because their story is a sad one in the case of Chrystal Kizer, or because of a political reason like Kyle Rittenhouse, which are not great reasons for them them walking free.
None of these have anything to do with justice, right? None of these have anything to do with human rights or any of the other moral things on which we judge government action. This is all arbitrary side facts that are determining what may happen to someone for years, and, or worse, what would allow them to be in a situation where they then go and do something crazy like drive a vehicle through a parade.
Yeah.
And now we don't want either of these.
And so what's the solution? Well, I think that there's a few things that I'd like to see happen. Number one,
let me propose the what I would guess is the standard Republican one immediately. Well, clearly bail should be way higher, or you should just have a standard where you say anyone who's committed something violent or something like that,
except for Kyle.
Except for, that's right, because that's
because he's our hero. We can't have him spend a year and a half in jail.
Well played, sir. My cat starts rubbing her face on my microphone. You can get back in my lap, kitty, but you cannot do that. So what we'll do is we'll just say, for the good of society, these people are going to be in jail without bail. Now we'll just deny them bail, right? If bail is the problem, we'll deny them bail, and that will solve the problem.
And obviously, when push comes to shove, they're going to realize that's a terrible idea.
I hope so.
And the reason it's a terrible idea is really not that complicated. It's because our whole system is set up that you're innocent until proven guilty. And if you're having people serve multiple year jail time before ever being convicted of something, I mean, that's a long time. I mean, that's most offenses. I mean, especially even violent offenses up until you get to things like murder or more extreme violent offenses only have several year prison times anyways. You know what I mean? So serving several years in prison before you even get to the hearing, before you even get to the trial, is a serious violation of people's rights. And so it therefore doesn't work. But the other answer, the liberal answer is, okay, we'll just set bail at $1,000 or get rid of cash bail altogether and just ask them nicely to come back for their trial. Because the reality is, and the liberals are right about this, that for most people, the reason they come back to the trial is not because of the $10,000 bond. It's because if they don't come back for the trial, they become a wanted fugitive. Excuse me, words are hard. They become a wanted fugitive and get hunted down, by U.S. Marshals. I mean, if it's a serious case, they get found and they get brought back anyways. You know what I mean? It's not like if you don't pay the bond, they're like, okay, well, I guess we'll drop the whole case. The law is still going to be enforced whether or not you have a bond in place. It was just to provide an additional incentive. And I also think that the original idea for this bond system was in a world where it was much easier to skip bond and disappear back into society. We live in a world today, a digitalized world, where who you are, your identity is verified on a regular basis and is something you need in order to perform basically every single function.
Right. You're best living a fraction of the life you could be living if you do manage to get through it. I mean, you would have to have serious connections to get all the IDs to live a full life and fly under the radar.
Yeah, theoretically, yes, you could get those, but you'd have to have such connections or such wealth that you'd be able to pay the bond anyways.
Right.
So those are the people we're talking about generally here anyways.
Right.
Are the people who can't afford these bonds.
It's a good point.
You know what I mean? If you can afford
Right.
all of that, then it doesn't matter anyways.
Right. And the point of going through all this is because hopefully if you're listening to us and you're thinking about it through for yourself, you're starting to see that the problem is actually not with the bail or with denying bail, right? Because in either case, when should you deny someone the right to walk around free? Well, it's when they're guilty of a crime.
Yeah.
When should you let people out and have the right to walk around free? Well, it's when they're innocent, right? Oh, these are the very things that a trial is going to try to establish, which is to say the proper answer to how to deal with a person can't be reached until after the thing that we're holding them for, right? Which suggests the solution, right? I'm going to read this is the Sixth Amendment to the United States Constitution. It's one of the first ones that was ever adopted. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state, etc. There's a key word there. Speedy. This person's been waiting for 2 years for a trial in jail, right? Now gets out on bond.
Yeah, and has been waiting a total of 3 years.
What do you do with your life while you're waiting to determine? Let's pretend you get out on bond. You're accused of being of murdering someone. What do you do with your life in the meantime? You go to your job and have a normal, like that's not going to happen, right? Like your life is on hold, even if you're not in jail to a large degree. What could possibly solve this? Well, it'd help if the trial were speedy, right?
Yeah, and actually speedy.
Actually speedy. I keep thinking of Roadrunner or Speedy Gonzales. This is my references to that word. I almost never use
Speedy
that word.
Gonzales is not Roadrunner. That's a different cartoon.
Right.
Yeah, okay. Just didn't want anyone to be like, hold on a second.
Yeah.
I mean, Roadrunner is speedy, and I don't know if he's speedier than Speedy Gonzales, but
I don't know. This is the real question.
The real question. We're gonna solve this next episode. We're gonna do a frame by frame, watch some old cartoons.
Right. It'll be beautiful. We'll see you then. No, seriously though, a speedy trial. People don't realize there are other cases than the ones we've mentioned where a speedy trial, the lack of the speedy trial inevitably causes injustice.
Absolutely.
Right? That's not in question. You cannot keep someone who is innocent without doing injustice to them, right? And it doesn't matter if it's the U.S. government or if it's some person keeping someone in their basement. It is unjust to take the liberty of someone who hasn't done anything wrong, who hasn't committed some injustice. There are cases where the most egregious abuser of a lot of laws is the CPS, the Child Protective Services, where while you're waiting for your trial, which is handled internally and is not with a jury in most cases, your kids are gone and you can't see them until you start complying and doing things like admitting your guilt and taking classes to learn how to be a parent that doesn't abuse their children, right? It's one of the most ridiculously unjust realms of courts in the U.S. But obviously your kid's gone for years before the trial is not acceptable. It's gross injustice. It's absolutely, it's vile, and we don't even think about it. It's not something even on people's radar.
And just like the fact that you have people on a regular basis who are spending years in jail before they're ever tried is something that's not it's not something that people think about on a regular basis.
No, it's not common knowledge for whatever reason. Now, obviously there are practical limitations or not limitations, what logistics involved here
Yeah.
in handling a trial quickly. But it's not like waiting a year is beneficial for gathering information for the trial, right? It's not like they're actively doing it the entire time.
No, it's in large part just because this is how governments run. You know what I mean? The justice system is not speedy
slow.
because what part of the government system is speedy?
Right. There's the incentives are never there. The direct connection to speedy and your paycheck is not there. Unlike with Amazon's delivery, which I don't even know when they changed it. I live in Dallas and I can often order something in the morning and get it in the afternoon. Like, what even is that? Why can't Amazon run the justice system? but seriously, like
no, it's true though. It's a matter of priorities.
It's a matter of expectations and priorities, and the government doesn't have an incentive to prioritize speedy. There isn't the natural economic incentives in which every hour is money, right? That's not how it works. But surely you could reform them in some way that could get them speedier than years. Years is unacceptable. Ideally, months are unacceptable, right? And we're looking at weeks.
No, I mean, I'm just spitballing here, but just to get the ball rolling of the kind of idea that could change the system is that you could have a hierarchy of criminal charges that are levied, and for each of these charges, you know, the DA or the prosecutor has to present, you know, they still have a hearing like they do now, you know, like a bond hearing, has to present that they do have evidence, right? That they do have evidence that means it's likely that they committed this crime.
Right.
So you can't just automatically choose the highest one in order to keep people behind bars. And then based off of whatever that tier is, you only have a certain amount of time before you can have that trial. Yeah. You know what I mean? So for example, okay, well, you know, you want this person, you have evidence that this person committed murder. Here's the evidence. Okay, we see that you do have evidence that is worthy of going to trial. You've got 30 days. From today, trial's going to be in 30 days. They're going to spend 30 days behind bars, and then we're going to have the trial, and we're going to have it out one way or the other. You know, okay, you've got this person for, I mean, obviously misdemeanors, they're not going to be in jail until the trial at all, but you've got, you know, medium cases, you know, violent robbery is, you know, 20 days, or maybe it's 30, just like murder, you know, something like that, where there's some kind of reasonable system put in place where this is how much time you have, and if the prosecutor can't assemble a case in that time, then that person gets to go free until charges are actually ready to be levied against them.
Yes, and I can imagine some kind of prosecutor or someone who, you know, is intimately involved in this system listening to this and being like, "You don't understand how many points the case is bottleneck." No, I do. I get that there are probably a dozen points at which things bottleneck, and we're not trying to lay blame on the prosecuting office or anything like that. You would have to change a lot for trials to be speedy. You would have to get into the nuts and bolts of it. You'd probably have to change the resources given to the prosecutors. You'd have to change all kinds of things. But for righting what looks to me like a grievous and commonplace wrong, that seems like it should be a priority.
Yeah, that reshaping the entire judicial system. Man, talking is hard. No, you're absolutely right that I'm oversimplifying it, saying just give this 30-day time limit for the prosecutor. That's an example of what I'm saying it should look like.
Yes,
what goes on behind the scenes in order to create a situation where that's possible. You're absolutely right. I mean, you'd have to have more judges on the docket so that you can try more cases on a regular basis.
Maybe, yeah, I don't know.
You'd have to have a system where you can get jurors more quickly, because right now the way the jury system is set up is super slow. But all of those things are possible.
Right.
You know, you can do things more efficiently.
Yeah, I mean, it's not like... yeah, I just keep thinking of... There are a variety of spheres in life in which we see such incredible efficiency that there's no question that it's possible that this could be more efficient. And it could be much more efficient. And there's no question that because the incentives are bad, that it's in many ways not as efficient as it could be, but strategically inefficient and poorly designed and so on. But you're absolutely right that you would need some kind of governing thing, something that you say, this is what it should look like. And then we rethink the rest of the system. We say, what's an acceptable time limit? 30 days for a complicated murder case or something. And then you look at all the other pieces and you say, how do we make this happen? What else has to change?
Yeah, what are these 12 bottlenecks?
Yes.
Talk to the prosecutors, talk to the defense attorneys, talk to the judges, talk to the bureaucrats who are in charge of assembling the juries. Talk to all of these people and all these processes and find out what the problems are and cut through them.
Yeah, and it would be interesting, and we should look into this at some point. See if there are other places that do this better. I'm sure there are. Sure there are. And I know at different points in American history, we've had speedy trials, really speedy compared to what we're doing now. Right. And it's not like the judges aren't going through. I mean, the prosecutors discard a lot of cases. There are a lot of cases that never are prosecuted, let alone tried, because of a lack of resources. And so you just let the least important ones go. You offer deals, you do all kinds of things because you just don't have the resources to fully pursue the slightest injustice, and give it as much time as the people involved think it should take. But at the same time, it's not like all of these cases are being tried. Do we just need to work through a backlog? You know what I mean? Like surely we could, all of the work. I'm not saying necessarily that they need to do more work, right? The more cases should be tried. I'm saying it's a matter of trying the ones we have now in a way that they're done closer to when they're committed, right? It's not necessarily more work. It's just organized differently. But yeah,
and I would argue that just from a practical standpoint, that is more work. From a logistics standpoint, like as someone who's in charge of moving things for a living, to have a deadline that's closer to when you first find out about something is more work.
That may be true.
You know what I mean? Same like with Amazon. You're moving the same amount of product, but to move it a week from when you order it, than a day from when you order it, does require more work for the same amount of movement.
No, you're correct. You're correct. That is
right. A very real cost, but it isn't necessarily, twice as much work.
No.
Because it is the same amount of movement. You just have to move things around in such a way to make that possible, which does require more effort, but
You're right.
But it's definitely possible.
That requires a level of organization and things that is going to require more effort and inconsistent.
Is going
to
to
be
increase
things ready.
The cost.
You're right.
Yeah.
That is correct. It would increase the cost. But I think in the long run, I think it'd be not only worth it for the sake of abstract principles and morality, that this would be better to have, to deal with things, it would eliminate a lot of these problems we're talking about with regards to bail, as well as numerous other injustices at different points in the system. But that it would be, I think it'd be a cost that would be, you never know with government agencies and the way they're using the money anyway. The very process of it may end up being cheaper, not because it, like you said, it should cost more, but just because you've
re-examined everything and realized all these inefficiencies.
Right, you found all
that
kinds
are just costing money when they shouldn't be.
Yeah, that it may be that these bottlenecks are not just ways to save money, but actual ways that more money is spent. But anyway, the whole bail thing is, like you said, it's a system that intends to do something when we need a system that intends to do several things, which requires changing the whole system.
Yeah. And one more thing I'd like to add about bail reform is that when you're looking at bail reform, when I'm looking at bail reform in a world where you still have to wait 2 or 3 years for a trial, what I would look at more than anything else is what is their threat to society. And that's what should be considered in that hearing versus what the bail amount should be.
Yes.
That that it's something that should be considered much more seriously, and maybe also why we should consider medium options of things that can be done, maybe incorporating things like house arrest on a more regular basis, because there are going to be more people who need to be restricted, who can't just roam free for 3 years, but we don't want to throw, a huge group of people into prison before ever being convicted of a crime.
Yes, that's a good point.
And that's something that I would look at.
That's a good point. And you could combine that with some kind of remuneration for people who are innocent during that time. And perhaps, I would guess this is probably already in place to some degree. No. There should be some kind of remuneration for someone who spent 2 years in jail waiting.
Remuneration is difficult for people who are convicted and then spend years in prison and are eventually
and then get exonerated.
Rarely get any kind of remuneration for anything.
That's upsetting.
It does happen sometimes, and it's very awesome when it does. But for the most part, they say, "My bad," and then you both go your separate ways.
Oh my gosh, I believe you, but part of me just hopes that's not true.
I know nothing. I have not heard of a single case where someone was remunerated just for spending time in jail before
waiting
the
for the
trial.
case.
Because that's just considered part of due process, which is disturbing. What I mean? That if you spend 2 years in jail and then are found innocent, I would argue that the state has wronged you, and you deserve some kind of recompense.
Right.
I believe that you should be able to sue the state.
Right.
And
any
say
any fair conception of justice would say the state has committed injustice there, right?
Mm-hmm.
The state doesn't get a pass because what? Because it's
because it was acting out of good faith is the current argument. Well, we thought you were guilty, so no. But that's how the current system is.
Yeah.
We think you're guilty, and therefore we can do whatever we need to in order to find that out, however many years it takes, which is all based on us anyways. You have no control over that.
Right, which becomes a much more plausible argument when it's speedy, right? If it's a week of your time and there was good reason maybe to suspect, or a couple weeks or even a month, but years. It's terrible. It's terrible. And this is only the beginning. This bail reform is the lightest topic we've decided to pick up.
Why, yeah, I think we ended up spending more time on it than we were planning on it. Because the other thing we wanted to talk about was self-defense. And in particular, self-defense when it comes not just to an imminent threat, but to other threats. Whether you call them constant or something else. And that goes back to Chrystal Kizer. The Chrystal Kizer case is one that received attention because because after Kyle Rittenhouse's verdict, a lot of people have been saying, hey, Kyle got out because of self-defense. Chrystal Kizer should be able to use self-defense in her case as well. And obviously her case is a little bit different than Kyle Rittenhouse's case. Kyle Rittenhouse is being chased by Joseph Rosenbaum. He's being, someone's trying to take his gun. He's being hit in the head with a skateboard. A gun's being pointed at him. These are all cases of imminent threat for self-defense in a more classic way. Like that's when we talk about self-defense, this is usually the kind of thing that it looks like. Someone points a gun at me, and so I point a gun back at them. Someone tries to kill me, and so I kill them. That's typically how self-defense is used. But there's a whole nother aspect of self-defense that's rarely talked about, and it's usually used in the sense of domestic abuse, and it's what do you do when someone has control over your life but isn't actively trying to kill you. And so in the case of Chrystal Kizer,
let me just interject before you get started.
Interject.
We are going to talk about not the details, but certainly the general overview of domestic abuse cases. And so consider yourself warned.
Thank you for that warning. I know you meant for the audience, but now I feel warned.
Consider yourself warned, Brad. This is at least heavy stuff. It's not going to be graphic, but
No, it is heavy. I mean, in the case of Chrystal Kizer, she's a victim of sex trafficking. She's being sexually abused. Her freedom is being restricted. In addition to that, um, exactly what degree of freedom she had, what degree of abuse she's suffering is a matter of specific details that I'm not privy to and didn't want to dig too much into. But the bottom line is that in general, her argument, the argument that, well, she had no choice but to kill her abuser in order to escape, is very rarely stands in court. Very rarely has that been an effective defense. And that's, when I found that out, I was surprised. I was surprised that that kind of argument wasn't given much weight by courts, and I couldn't quite figure out why. And me and Dan have talked about it for a while, and and there do appear to be some reasons for it, but how valid those reasons are is an interesting question.
Looking into general self-defense laws in most of the states, there are a few states that have kind of unique self-defense laws, but most of them are fairly similar and within a range of the castle doctrine and stand your ground thing. We're not going to get into the details of those. But in each of these, in most states, you have a written exception within the law that says, hey, the circumstances when it's a case where the two people living in the same household, these general rules of self-defense do not apply. And they may tweak it a little bit. They may completely eliminate it. But one way or another, the general self-defense claims simply are not applied to these cases.
Mm-hmm. And
were applied in a more limited way.
No, I lost what I was going to say.
It's and that puts you into a strange situation. It's not like, and I think the reasoning for this, like if you just say, why would you change that? Why would you change that standard? If it's not because it's suddenly immoral in certain circumstances. I mean, if this is a good general principle, self-defense, then you would want it universally applicable. But it seems to be particularly because of how difficult it is to navigate in these circumstances.
Yeah, and the Chrystal Kizer case is a little bit different from these domestic abuse cases, because typically a domestic abuse case is between two spouses. You've got a spouse abusing another spouse. Often it's, a husband abusing a wife, but there's also a significant number of cases, a large minority of cases where, the wife is abusing the husband, or, boyfriend abusing a girlfriend, girlfriend abusing a boyfriend. And that's a domestic abuse and is a little bit messier. With Kaiser, it's different because it's not her spouse who's abusing her. It is just it is a man who's abusing, at this point he started abusing her when she was 16. She kills him when she's 17. And honestly, the domestic abuse cases can be messy and can be complicated. For me, the Kaiser one is pretty straightforward. Mm-hmm. You know what? You have this man who has been abusing, Chrystal Kizer, who has actually been selling her to other men to have sex with her, and at one point physically attacked her at least once, and in response she kills him, and you have to believe that this 17-year-old girl who's been abused for a long time doesn't feel like she has a lot of options. And of course the automatic response from the government, from the state, is always, well, you need to leave that environment, you need to go to the police and report them. And anyone who's listened to Crime Junkies or seen any of the many movies about these kind of issues, you'll understand that when you're in those situations, the options that you have are always going to feel very limited. Even if you technically have more options, in reality, it's not that way. When you're being held by someone, you don't have options in the way that normal people have options, especially when you've been there a long time and you're a minor, and your whole world is different, is just this person and this world that you're in, and your options. There is no going to the police in so many of these cases, not always, but in so many of these cases, there's constant threats that if you go to the police, you're going to be killed, or you're going to have this or that. And in these cases, it seems pretty clear to me, not that they have to kill their their abuser, but that if they do, that the argument of self-defense is legitimate. That I feel like there should be a self-defense clause that every state should have that says it doesn't have to be just imminent danger, it can also be constant danger.
Right.
A great example of this that actually was featured on Crime Junkies, which is how I heard about it. I don't listen to Crime Junkies, but my wife does. And it's about this Canadian case where this woman, Jane Hirschman, was married to an abuser who physically abused her on a regular, physically and sexually abused her for years, also abused their children, and made many threats that there's no way she could get out, that if she went to the police, that he would kill her, etc., etc. And so one day she kills him in his sleep. And according to classic self-defense laws, there is no justification for that. While he was asleep, there was no way for him to hurt her, right?
Right.
He's asleep. She could have technically grabbed her children and physically left their home, right? In that sense, there is no self-defense. But it's not that simple. And because of the threats that he levied against her, because of the fact that they're married, because of the fact that they have joint custody of their children, which means she can't just flee the state. He can accuse her of kidnapping her children. She has to go to the police. It's her only option. She can't just disappear. She has to go to the police. And when she goes to the police, there is a chance that he absolutely can get to her. There is a chance that he does know someone at the police, like he may have threatened, and that he may come and he may kill her and may kill her children. And the argument is made that she believes that, and because she believes that, and it's a reasonable fear, that she does have the right to self-defense.
Yeah.
And she actually ends up being not guilty for murder. There end up being some appeals, and she ends up getting convicted of manslaughter and spending a short time in prison, which is so much better than murder. And you can argue back and forth about the manslaughter, but the point is it was a groundbreaking case in Canada about these domestic abuse cases, because she was going to be convicted of murder. Because according to the basic self-defense laws, there's no place for that constant threat. And that constant threat needs to be considered because it is very real, even though it's different.
It is. I mean, it's not an important part of the self-defense plea is that that it is reasonable for you to fear for your life. If in a case where you use self-defense and actually kill someone, you have to be able to, justify that level of force. And that generally means you've got to be able to make a claim that you're reasonably afraid for your life.
Mm-hmm.
The fact that the person was asleep, which in several of these cases, we have another one where a woman did that, and she had been essentially tortured in things and kills her husband in his sleep, and is then convicted of murder. I believe she's convicted, right?
Yeah.
What is her name?
You're talking about
Nicole Adamondo. Yeah.
Mm-hmm.
Yeah, he has a history of abuse. She kills him in his sleep. And the idea is there's no pressing threat. There's no imminent threat. There's no raised gun at you. There's no one attacking you. Now, if he had been maybe hitting her and she grabs a knife and tries to get him off and he dies of the wounds, right? That's more classic self-defense. Mm-hmm. Now, again, that becomes complicated in a domestic abuse situation where both people are in the home and there's a relationship and a history. And you can see how the courts would have a difficult time sorting out the facts and showing these things depending on the evidence that she has of the abuse and of the threat, right? You've got two people sitting in a home together regularly, and one of them walks out alive. That's almost by definition, you're not going to have witnesses, right? You're not going to have, there's going to be time for them to clean it up. There's going to be time for all these things, right? All of this complicates.
You don't have what you have in a normal self-defense trial like Kyle Rittenhouse, where that one was so clean in comparison, because you had video footage, you have witness testimony, you've got, all this material evidence that stacks together so that in general, they actually had a very clear picture of what happened. The whole case revolved around, the ramifications, the legal ramifications of what happened, but not necessarily of what physically happened that night. Most of that data was pretty concrete. When it's domestic abuse and then a subsequent, death, what actually happened that night becomes much more complicated. And what happened in that household in the years prior is much more complicated.
Yes. Ideally she has been documenting things and has some evidence that can show that the wounds she has, connect to this man and all of these things. But it's just the factual side of this case in which they establish what happened is very difficult in a lot of these cases. But the principle shouldn't be that difficult. As Brad was saying, that if you have a threat that if you go to the police, you will be killed. It's possible you go to the police, you've been abused, you actually have your story is true, and the police, for whatever reason, don't believe you, or you don't have the evidence to prove it in court, or you don't have, or it's going to take time. There are some places, Alabama is a state that has this requirement, to make a self-defense plea in a domestic situation. You have to have a court injunction against the person. This requires multiple visits.
And if you don't, then you can't make the self-defense plea.
The self-defense is off the
table.
And
that means you have to have already started that process before you needed self-defense.
Right.
Which has obviously some practical problems.
Right. In most of these cases, that may have led to your death. Right? You start that process, the person finds out about it, that may be it for you. You try and record them abusing you, right? And they go, what are you going to do with, they catch you. This is an extremely difficult situation for you to interact with the police. And it's actually dangerous to you. The idea that you can just leave with that perpetual threat hanging over your head is just not, that's not a, what's the word? That doesn't really take into account not only what their experience emotionally, but really what they should rationally be afraid of. I think it's entirely rational for a woman in those circumstances to shoot the man in his sleep. I don't think that's overdoing it, or that she should have taken that opportunity to flee to the police in some cases. That may have been the solution. Now, what do you do with that person, and how do you sort that out in court? Hopefully, you can mount the evidence for a self-defense plea, but in most cases, that's not even on the table.
No, and that's the thing, is that the steelman argument to all of this is, well, the problem is if
the problem is if you get COVID, you're gonna die.
Yeah.
Just kidding.
I'm over here dying. That's the problem. The problem is that if this becomes the new self-defense, that if you've been threatened by your spouse who's also been abusing you in some form, you have the right to kill them, even in their sleep, then, and combine that with the fact that so many murders are already spouse to spouse. That spouses kill their spouses on a regular basis.
Relative to other murders.
Relative to other...
Yeah.
Yeah, obviously it's not that common. Excuse me. Thank you for
Roughly
clarifying.
50% of marriages end with your spouse killing you.
We're talking about court cases. We're talking about murder. In that realm, a large number of those, a statistically significant number of those, are spouses killing their spouses, which means that if you create a easy legal defense that you just say, oh, my spouse was abusing me, but there's no record of it, and they threatened that if I went to the police, they would kill me, and so I had no choice but to kill me, you could create a scenario where a huge number of people get off scot-free using this self-defense argument, even though there's no physical evidence even of a fight necessarily. You know what I mean? And I think that's the potential fear, at least, kind of like the potential fear after the Kyle Rittenhouse verdict was, anyone can kill anyone as long as they feel threatened, which is funny because that is kind of how it works now. And yet in terms of regular self-defense, that if you're reasonably afraid for your life, you have a right to self-defense given certain parameters based on the state that you live in.
Right. And that
it doesn't change the fact that there is still some evidence that needs to be presented in such a way to argue that. And the same should be true for domestic abuse cases. Our goal here isn't to create a situation where, if a spouse dies, we say, well, it was probably self-defense, so don't worry about it. You still need evidence. These details are really important. The problem we're bringing up right now is that right now the burden of proof is set up in such a way, like that Alabama state law, that there are many cases like Chrystal Kizer where everyone in the public is like, yeah, this person was just a victim. And yes, they did something that may or may not be completely innocent. There may be some, depending on the specific details of the case, because something we want to remember is that we don't want to overgeneralize.
Right.
Is that the details of every one of these cases are different, and those details do play a large factor in what happens. We're not saying that domestic abuse in every case should result in the abuser's death. You know what I mean? That is not the solution that we're proposing. We're also not saying that all of these people are innocent. We're just saying there needs to be a shift in how we view these cases and how the law views these cases. And that's something that, like that one case I mentioned with Jane Hirschman did in Canada, as it started to shift that perspective. And maybe that's something we can get as people have more attention on Chrystal Kizer and her case, is that we start to shift both the public view and also some of the laws. The judges and the juries rule based off of what the law is. And maybe these laws need to be changed so that there is a place for these people who are clearly victims of horrible, horrible circumstances, who don't end up spending the rest of their lives in prison afterwards. You know what I mean?
Yes.
We don't want to create a legal situation where people are in horrible situations, who are being abused, who have, as far as they can see, no option except continue to be abused or kill their abuser and spend the rest of their lives in prison.
Yeah.
Because I think you could talk to some of these people. I think you might talk to Jane Hirschman, who at one point was going to spend the rest of her life in prison, and she would say, yeah, I was willing to pay that price for my children. Her children were being abused. You know what I mean? I would pay that price. You know what I mean? But doesn't mean that the law can't change so that they don't have to pay that price for something that they, in many ways, were forced to do because of someone else's choices.
Right. You see this in a couple cases. There are things where, like, in some ways, this is a kind of movie trope in crime shows where you get the person who kills someone, and that someone is truly evil and doing terrible things to people. And the person has this conversation with the police or with the lawyers or whatever, and it's like, yeah, it was worth it because I'm protecting these people. And what is worth it? Me in jail for life for murder versus letting them continue what they're doing. But what if that weren't the only solution? What if we could say, maybe in some cases, killing that person was not the perfect solution per se, but there are circumstances in which the police really aren't always in a position to help, right? Where you can't, again, I can't help but think that sometimes people assume that's the police's job, right? And so to take that into your own hands automatically makes you some kind of criminal. And I don't think it should be that way for the same reason self-defense laws should be justified, and that there should be some possibility in certain circumstances for people to be justified in what appears to be murder, but is actually a kind of self-defense, right? It's a self-defense, but not in one in which they're being, in which the threat is imminent, in the sense that someone's pointing a gun at them or actually trying to hit them or something like that. And I think
no, absolutely.
Yeah,
and on the flip side, the other thing we should look at is obvious, is trying to create a situation where people aren't placed in that situation. You know what I mean?
Yes.
That the reality that people are ever in that situation where they feel like there's no option except to kill their abuser is really a condemnation of the system. You know what I mean? More than anything else.
System and society in general. I mean,
no, you're absolutely right.
Hope that
the system is too strict.
Right. This could be your friends, right? This could be someone you know. And you hope that that's not the case, and that they would reach out to you, or that you'd be the kind of person that could maybe, obviously you can't expect put the weight of being able to see that this is happening on yourself necessarily, but you hope that we would be in such a position that someone in that situation could leave and go to your house, or something like that, and have the help they need from people around them. Not be so isolated that they can be completely controlled by someone in this circumstance, in a terrible circumstance. But yeah, it's society, and as you said, there are some systemic things that could change too.
Yeah, and the systemic things are things that have improved. I'd say in the past few decades, there are many more resources for people who are in. I mean, domestic abuse resources in general have improved greatly in the past few decades, which could have potentially helped those cases. I mean, there are cases that are 20, 30 years old that could have had better outcomes.
Yes.
In today's world, but it doesn't mean that everything's as good as it could be.
Yeah.
As we're kind of wrapping up this discussion of domestic abuse, I just want to kind of clarify what our intention is here. Our purpose is as we're looking at these cases, our goal here is justice, and that is what we want the legal system's goal to be. When we're talking about bail, what we're looking at is what is just, and that's why comparing, Chrystal Kizer versus, Darrel Brooks is a good example of that, because in both cases, you kind of have the two extremes, where in each case, the bail system as it stands now has created an injustice. On the one case where you've got someone who spent 2 years in jail without ever being convicted of a crime. And then on the other hand, you have someone who, after being charged with multiple crimes, serious crimes, is able to walk free a few days later, and because of that is able to commit another crime that kills several more people. And so on both sides, you see these glaring problems with the bail system. And our goal when we're trying to rectify those problems is not just to rectify those specific situations, but to come up with rules that are just, that can be applied in different situations.
Yeah. A principle that would solve both of these and other potential cases.
And then that gets to the domestic abuse, and the same thing with domestic abuse laws. And the final thing that brings me to is that one more solution that we haven't yet talked about is more flexibility in jurors' ability to rule on cases. And what I'm talking about here is basically jury nullification.
Mm-hmm.
That one solution is the fact that when you're in a situation where the jury across the board says this person who's being charged with this crime is clearly the victim, clearly didn't do anything wrong, but as the law is written right now, they are guilty, so we're just going to charge them as guilty because that's our hand has been forced. You know what I mean? Our hand has been forced by the law, and so we have no options. So one solution to that is saying, well, if you're in that situation, as the jury, you have a place to say this law doesn't make sense, so we're not going to convict you.
Yeah.
And it's an incredibly scary thought for so many people, but really it's not that crazy, because if you're in a situation where everyone looking at this case is like, yeah, you shouldn't be convicted, but yeah, as the law is written, that's what should happen, then don't do it.
Right.
And allowing that to be an option for a jury is a fantastic idea, because the whole purpose of the judicial system is innocent until proven guilty, is to protect innocence first. And by allowing a jury to do that is a great opportunity for just such a thing.
Yeah, the reason it's a jury of your peers is so that they can in some sense judge you, right? By not just determine the way they frame it is the jury's supposed to determine the facts of the case, right? The facts are presented to them and they're supposed to come to, if they can come to a unanimous conclusion, as they usually are required to do, then the facts have spoken, right? There's a clear, if your peers can reach that conclusion, then that says something about the nature of the facts and what it appears that you've done. But as Brad was saying, there's more to it than that. This is an opportunity for you to say, and they should be punished, and they shouldn't be. And if that's the ultimate goal, is justice on the juror's end, not just determining the facts, but what would be just here, then a jury nullification, where they would say, it appears that you are guilty of the law, but we deem you innocent because the law is unjust. This is as good a point as any place to check the system and to say, like, who better to check the system?
And they don't even have to say that the
12
law
people,
is unjust, but
no.
that the law is unjust
in this case. Yes. In this case, you shouldn't suffer the consequences.
Jury nullification is not canceling the entire law.
Yes.
It's just saying the law doesn't actually apply as it was intended in this case. And when you look at it that way, it seems quite reasonable.
Well, and that happens all the time. Like, the people who make the laws are not able to perceive all of the every circumstance in which this law will be applied.
And yet we require them to based on our current system.
Yes, the current system assumes they did, and that we have to interpret it accordingly. And that's just not the case.
It's stupid.
It is stupid. The 12 people who are put in this situation are going to be the best informed on whether or not the law applies in this situation, and they should make that call. Yeah, that's a really helpful clarification. Yeah, people hear jury nullification, they're like, I don't know what this is, but it sounds scary. Nullification.
Yeah, it sounds like anarchy, and it's not supposed to be. It's not actually an extreme concept. It's just one that we don't currently use.
Mm-hmm. It's just generally not used, yeah.
Mm-hmm.
All right. This has been productive. With that, I guess we'll pause. Thanks for listening.
This has been an episode of Rethinking Politics. You can find us on all of the major podcasting apps or on YouTube. You can reach out to us at rethinkingpoliticspodcast@gmail.com, or you can visit our website at rethinkingpolitics.podbean.com, where you can support us via Patreon. Thanks, and have a wonderful day.